Hey everybody, today we'll be dealing with another important topic in the Indian Constitution, that is Article 14, which talks about the right to equality. In this video, we'll be dealing with first the introduction to what is our right to equality, second the meaning of it, third the important concept relating to it, fourth the applicability of it, fifth the exception to it, and to those who will be seeing this video till the end, I have a bonus one for you. Okay, so to begin with, right to equality and furthermost, Article 14 of the Indian Constitution, it is very much important to know what is right to equality and where it has been dealt in the Indian Constitution. So, right to equality as a whole chapter has been dealt under Part 3 from Article 14 to Article 18 of the Indian Constitution. Alright, and talking about right to equality, Article 14 is just a part of it, which provides a general principle as to what will constitute equality and how it is to be practiced. Alright, so now talking about the introduction to what is right to equality. Right to equality is the basic structure of the Indian Constitution, which is also provided in the preamble of the Indian Constitution. Okay, so let's begin with Article 14 of the Indian Constitution. Article 14 talks about equality before law. It basically has two main aspects. First is the equality before law and equal protection of law. It reads as, okay, so I hope you went through the article. Now, talking about the various aspects in that article. First, we'll be talking about the word state. State has the same meaning as it has under Article 12 of the Indian Constitution. I have dealt with Article 12 in detail and I'll put the link to this video in the description box for your reference. Now, here the article says the state shall not deny to any person equality before law and equal protection of law. Here, these two terms have two different concepts. Alright, the term equality before law is stated as a negative concept and has its origin from the English law, while equal protection of law is termed as a positive concept and has its origin from the American Constitution. Alright, so before moving further, let us understand why both these terms are stated as positive or negative. Equality before law is stated as a negative concept because it instructs the state to not give or provide any privilege to any person. Alright, that means it tries to prevent discrimination amongst the people. While equal protection of law is termed as a positive concept because it tends to promote equality amongst equal. It says that equals must be treated equally and unequal must be treated differently. Let us take an example. Say for example, the right to equality. Alright, each and every one living in this country has a right to educate themselves. That is equality before law. You cannot tell anyone not to take education on the basis of any grounds of discrimination. Alright, when we talk about the equal protection of law, it says that it provides for certain important and certain reservations for a particular group of people or particular class of persons, so as to promote them, so as to bring them socially and educationally upwards. So that is equal protection of law. I hope I'm clear with both these terms, and now we'll be proceeding with the third thing, which talks about the applicability of this article. Okay, now talking about the applicability of Article 14. Article 14 is applicable to all the persons, as we have already seen in the definition. This is not I am who's saying this. This is provided in the provisions itself. It talks about the state shall not deny to any person. Here, any person includes the following people. First, the citizens. Second, the non-citizens. Third, the company. Fourth, the association. Fifth, the body of people, a body of association. It includes legal and juristic person as well. That means right to equality under Article 14 is applicable to all. The reason being it provides applicable, this article is applicable to all the other, like to any person, is that it is a general principle. Alright, and the various particular provisions relating to Article 14 has been dealt under 15, 16, 17 and 18 of the Indian Constitution. This article only provides with a general principle and not the entire solution to the problem of inequality in our country. Alright, so next, now we'll begin with the main concept. So before moving further, if you haven't subscribed to my channel yet, then please do subscribe to it. And also press the bell icon so that you can get all the notification. Watch my video till the end so that you can get the bonus that I'm going to tell you in the end. So, we were talking about Article 14 and it says that equal must be treated equally and unequal must be treated differently. Which means it provides that certain special legislation can be made for the upliftment of the lesser privileged one or the unprivileged one. Alright, but does it allow making legislation for everyone? No. The answer is no. In short, Article 14 provides for classification, but it prohibits class legislation. Now you must be wondering, what are these two terms and what do they stand for? So, providing or permitting classification is that there must be some differentiation if required, but that differentiation or privileges that are provided must be based on certain reasonable, real and substantial causes that should match or that should help the legislation which is enacted to achieve its objective. Nahi samajh mein aaya? Let us go into it. Let us take an example. If we made a law, say for example, the parent law, which talks about the right to education. But we also provide for certain laws which gives education or special benefits in education to certain underprivileged section of the society. Here we are although making a classification, we are differentiating, but this differentiation is real and substantial, and it is also very important to fulfill the objective to provide education to each and every individual in our country. Which means that those classifications or those distinctions which aims at achieving the real objective of a legislation or legislature, then in that case, such classification or differentiation are good and are helpful. The second term here is it prohibits, that is Article 14 prohibits class legislation. Now talking about class legislation, it means that, say for example, there is a group of people in a society who are already privileged. And if we are making certain laws which are enhancing their privileges, then in that case, at the same time, these privileges are hampering the rights of other underprivileged section of society, then such legislation are against the right to equality and are against Article 14. To make it simple, those legislation which are arbitrary, which are artificial, and third, which are evasive, and they are creating differences or making a difference between unequals unreasonably or without a reasonable cause, which do not have any effect on the main objective of the legislation, then in that case, all these legislation or class legislation are unreasonable. Therefore, Article 14 restricts or prohibits class legislation. I hope till now I'm clear. Now let us further move with how we can differentiate between what is a reasonable legislation or class legislation or what is a reasonable classification. There's a test to it. The test is based on two main important terms. First is intelligible differentia and third is the differentia must be reasonable. Okay, now what is intelligible differentia? Intelligible differentia is nothing but we can understand it with an example. What I have been taking from this since the starting of the video. Say for example, right to education and making of a separate legislation for the underprivileged students. This is intelligible differentia, which talks about the equal must be treated equally and the unequal must be treated differently. And this difference must be reasonable, intelligible. And the second is differentia must be reasonable or must be in relation with the object that the legislature sought to achieve. Alright, I hope I'm clear with both these tests. So, in the beginning of the video, I've told you that Article 14 is applicable to all persons, whether they are citizens, non-citizens, legal person, artificial person, juristic person, companies, association, body of individuals, etc. But does that mean that it does not have any exceptions to it? No, it has an exception. And although it has 4 exceptions mainly, first exception has been provided under Article 361 of the Indian Constitution, which says that a President of India and a Governor of a state cannot be questioned in any court of law in the exercise of its powers or duties as a President or as a Governor of the state. Second exception that we have here is during the proclamation of emergency. When an emergency has been proclaimed in India or in any part or in any territory of India, then in that case, fundamental rights remain suspended except for Article 20 and 21. The third important exception to Article 14 is that where there are certain special laws made, then in that case, Article 14 do not stand as equality or cannot provide for equality. Those special provisions are to be dealt as they have been provided under special law. Say for example, if there are certain proceedings which needs to be taken care or which needs to be proceeded as they are provided under the martial law, okay, then in that case, right to equality shall not prevail over these. Here the last is, when talking about a normal individual or a private individual, then that of the public individual or the public officer, they have certain differences. A public officer has to perform its duties. Say for example, a public officer is entitled to arrest a person who has committed a cognizable or a non-cognizable offense, while a private individual can only do that under certain specified circumstances. Alright, so this is a distinction. You cannot claim that a private individual must also be given the opportunity to arrest someone at every possible cause. Like any other provisions, Article 14 has also evolved with time. Earlier, it was only confined to intelligible differentia and the relation between the differentia. But with time and with the judgments and the precedents of the court, of the Supreme Court and the High Courts, there has been laid down that Article 14 does not only provide with intelligible differentia or classification, but is also aims at striking down arbitration or arbitrary action of the state. So the new concept states that it does not, or Article 14 is not only confined to providing with the intelligible differentia, but has a broader horizon where it aims at detecting and also protecting the citizens against the arbitrary actions of the state. Now to those who have been here with me from the beginning till the end, there's a bonus for all of you. In this, we will be dealing with 3 important case laws. So to begin with, bonus 1. First case law here is Abdul Rehman versus Pinto. In this case, the court held that there are varying needs of various sections of the society, and therefore they cannot be treated as similar to those who are privileged or who are already upgraded, and therefore there is a need and there is a necessity to bring them to those who are already privileged. Therefore, it requires that the underprivileged must be treated differently from the privileged one. The second important case, which is related to the new concept of equality before law, which deals with protection against the arbitrary action of the state, is E.P. Royappa versus State of Tamil Nadu. In this case, the Supreme Court held that the term or the provisions of Article 14 cannot be confined to a restrictive definition of intelligible differentia, but has a very broad meaning, and arbitrary actions of the state are also under Article 14, and therefore the citizens and the persons must be protected against these actions. The last case in this train is Maneka Gandhi versus Union of India. In this case, the Supreme Court finally held that Article 14 is not confined to only providing protection and to bring the unequals to the level of equals, but is also protecting the citizens and the people of the country against the arbitrary action of the state. And because of Article 14, state cannot act arbitrarily and provide undue advantage to a particular section of the society and ignore the rest. It has to treat all the people equally. Here equally means those who require better attention or who require more attention must be treated better and in a different way to those who are already privileged or uplifted. So that was all from my side under Article 14. I tried to cover each and every aspect that was required. In case I missed out on some point, do let me know in the comment box below. And also you can go and follow me on my Instagram page. The link to it is in the description box. And also do follow me and do subscribe to my channel. Like this video if you find it informative, and press the bell icon so that you can get all the notification to all the videos that I post. Thank you till we meet next.